Hello, everyone, and welcome back to Face the Jury. For our regular listeners, you know we have a variety of interesting guests, including former clients, attorneys. We've had expert witnesses, but today is a first as we welcome the first judge guest to the show. And I could spend a lot of time recounting all of the accomplishments of our next guest, but just to note a few highlights. Judge Alvin Wong is a judge with the State Court of DeKalb County. He is a first-generation American who immigrated with his family from Hong Kong when he was a teenager. Judge Wong settled in Virginia, went to military school, an experience that I share with Judge Wong. He then went on to Auburn University, made his way to Atlanta, worked in the insurance industry for a while he attended law school at John Marshall Law School in Atlanta. Judge Wong was a trial lawyer, doing a variety of what we call courtroom law, criminal cases, civil cases. I used to call it threshold law when I started my practice. Basically, anything that crosses the threshold is what you do for that day. But he did that for, I believe, about 2 decades before he ran for judge in DeKalb County in 1998. He was obviously successful in his campaign, and he became Georgia's first Asian Pacific American judge, one of many firsts for Judge Wong. He is active in his accountability courts and co-founded a DUI court to help find an alternative for folks struggling with addiction. He's a past president of the Judicial Council of Georgia. He is I believe, senior judge in DeKalb County for this term. Judge Wong is also an animal lover and serves on the board of the Lifetime Animal Project, a nonprofit that helps turn Atlanta animal shelters into no-kill shelters. And if you happen to be around Decatur Square at lunchtime during the week, you will often see Judge Wong out walking his dog, Daisy, I believe is her name. Coco, I'm sorry, Coco, going on memory here. And from a trial lawyer's point of view, Judge Wong has developed a reputation for being tough but fair, always looking for practical ways to resolve disputes. He is a real pleasure to know as a judge, and we enjoy seeing him at our trial lawyer events around the state. And it is my pleasure to welcome you, Judge Wong, to Face the Jury.
Thank you, Lloyd.
And my goal is to do as little talking as possible, and so people who tune into this episode can learn more about you. And I'm just going to tell you, Judge Wong, I've done my homework, and I have talked to many of my colleagues, and I said, look, I'm going to have Judge Wong on my podcast. What would you like me to ask him? Hard-hitting questions, not the softballs that you're probably used to. So I appreciate you stepping in the arena and being with us today.
Look forward to it.
Well, for folks who don't know you, Judge Wong, I know I've given a little bit of your personal bio, but I feel like this is a jury selection. But tell us a little bit about yourself, a little bit about your story, and how you came to be a presiding judge in DeKalb County.
Well, Lloyd, thanks. I did go to military school. I was 14. My brother, who was a year younger than me, at 13, the two of us were born and raised in Hong Kong, come from a middle-class, pretty typical middle-class family. My father had served in the United States Marines during World War II. So we have good ties with the United States. He worked for a company out of Chicago. And one summer we were traveling, coming to the States. My mother looked at my father and said, these well-behaved children don't get out of here. They're never going to amount to much. So my brother and I were both shipped out to military school, and my father shook hands with me on a late August afternoon and said, do well, son. I'll see you next summer. And thus began my journey to the United States. I was 14.
Well, were you raised English speaking? Or was it a complete culture shock for you when you got here?
Well, that's an interesting question, because Hong Kong, as you know, is a British territory back then, before the handover in 97.
Mm-hmm.
So while I did not speak English, the sound, the phonics of English were not strange to me.
Right.
So when I came to the States, I'm in the middle of the the woods of Blue Ridge, up in the mountains in Shenandoah Valley.
Mm-hmm.
There's no Chinese speaking up there. So you adapt fairly quickly.
Yeah.
And I did.
And then you made your way to Auburn University. How did that happen?
My next door classmate, I tried to go to college. I applied to, I had a couple of choices. VMI, Virginia Military.
That's where I went.
Oh, you're a VMI man.
I went to VMI. I didn't know we had that connection.
To this day, I somehow somewhat regret not having gone to VMI.
Yeah.
As you can imagine, after 4 years of military high school, the last place I want to go to was a military school where there's no women.
There were no women when I was there either. They have since changed that circumstance. It's co-ed now, but interesting.
So I rejected VMI. I could not get into Davidson, which is where I wanted to go to school. And my next door classmate, the room next door to me, said, I'm going to Auburn.
Mm-hmm.
I said, where is Auburn? He said, it's in Alabama. I said, where's Alabama?
Go west.
I ended up at Auburn. The long story short, my friend, my classmate, who was the brightest fellow of the school, he flunked out after drinking for 2 quarters.
Mm-hmm.
I stayed. I finished Auburn. I moved up here to Atlanta.
And you, as I mentioned in the earlier comments, as I understand it, you started off, basically doing courthouse law, going to the courthouse early in the morning, looking for assigned cases, meeting your clients. Tell us a little bit about that.
Well, you call it threshold law. I call it green law. Is it whatever? If you have the green, I have the law. So I graduated from John Marshall,
mm-hmm.
an unaccredited school. I had no hopes of landing regular employment, although I didn't try very hard doing that. I was pretty stubborn about being independent. So I would go to the jails, Fulton County Rice Street, the jail. Back then, they had the magistrate judge come in at 6 o'clock Monday morning and make assignments. And if you show up early and sign up on the assignment sheet, they'll feed you breakfast. I had clerk for a lawyer named Hugh Head. After I took the bar, between the bar and I guess that was February and passing being licensed in June, I got a clerkship. I just went in his office one morning and said, I'm not leaving until I talk to him. And eventually did. And, the good Lord takes care of idiot and children. And on the phone that morning was a colleague of his from the GTLA National Board from Maryland who had a niece arrested overnight. So old man Head, as I'm sitting there, he's telling me I don't have anything, this and that. The phone rings. His buddy calls. He puts me on the extension. Afterwards, I gave him my best pitch of criminal procedure. And he looked at me and pulled out a roll of $100 bills out of his pocket, handed me 2 of them, opened his drawer, tossed the key across the table. I'll see you at 9. That's how I got my first job.
And that's how it starts. Isn't that amazing?
And then, and then about, I guess, 6-8 weeks after I would pass the bar exam, he says, we're going on trial. Right here in DeKalb County Courthouse in front of Judge Bulldog Hubert. Back in those days, you can still smoke in the courtroom.
Right.
So there's this little diminutive judge puffing on a cigarette. We're trying this fraudulent set-aside case against a doctor. I'm handed this file. It's probably gone through 4 or 5 associates. Dusted off, walked into the courthouse that morning, and they says, okay, you're going to make an opening statement, and you're going to take the first witness.
I'm guessing you've never tried a case at this point.
Oh, my gosh. barely seen the courtroom.
Yeah.
So we go in there and we started the trial, and I did okay for about 5 minutes, and then I started examining the witness, and all I got was a string of objections from opposing counsel. And about this time, I need help. I'm turn around, look at my boss. He's sitting there. He's got his back turned to me, and he's got his glasses twirling in his hands, looking at the ceiling. I said, "Oh boy, this is a setup if I ever saw one." So I got my first taste of a trial. So at the end of that, I got sweat running down my. Back in those days, I still had hair. Beads of sweat. I can feel it dripping down my sweat in my shirt. And that was my first trial. And at the end, eventually, I think we settled that thing. And he called me into his office the next week, and he says, "I signed you up for a Dale Carnegie course on how to win friends and influence people. And I've already paid for it. And you start Thursday night." So I took an 8-week or 12-week class of how to win friends and influence people. And so that was like June, July. It was about September, he called me in one day. He says, "Bring me all your files, bring the checkbook." When I got first hired, he made the secretary turn over all the checkbook, learn how to pay the bills, told me my secretary was an old typewriter, not even a computer, and so on. That's how I learned to type, 2-finger typing, and how to run a law office.
Button peck.
And he called me in one day and he says, "I think you can make it, but you're going to have to go see about it doing it on your own. So bring me the checkbook, bring me the files." He wrote me a check for about $5,000 and said, "Good luck to you. You can let me have your key."
And said the law offices of Alvin Wong is now in business.
At Colony Square at a rate of $100 a month.
Well, I'm at Colony Square right now, and I will tell you they have increased the rent since you were here.
Well, I was at the 400 building.
That's where I am. What a coincidence.
And a lawyer named Barry Weiner. I think Barry is still there. I don't think he's at Colony Square, but he was a part-time professor at John Marshall. I met him that way, and I told him my plight about being unemployed and so on. He says, "Well, I got a little office in my office. I'll rent it to you for about $100 a month." I said, "Deal." So I printed some stationery, hooked up a telephone, bought a typewriter, IBM Selectric, mind you, and went into practice.
That is fantastic. What a great story.
So you go to Fulton County Rice Street, and if you sign up back then, it was $25 a misdemeanor and $50 a felony. Okay, a case. So if you got appointed, you had to take it from beginning to end. But if I got 2 felony assignments, I pay rent.
You pay rent. You've also got 2 new clients who have friends. That becomes 4 clients who pay a little bit more.
I wouldn't worry about those kind of clients back then. I was more worried about making rent.
I understand. You mentioned something too that resonated. You said that your boss had told you to read Dale Carnegie's How to Win Friends and Influence Enemies. I still tell young lawyers that is the essential book to start off their practice with. It has the foundation for marketing, for getting along with judges, with getting along with your colleagues, building relationships. And it's gold, and it's ageless. It's a little bit dated. If you listen to the stories they tell, they talk a lot about, timber, people working on railroads and things of that nature, but excellent book. So you're off on your career. You're working as a trial lawyer. You're getting cases. You're getting your feet under you. At some point, you decide that you are going to run in DeKalb County as a judge. How did that decision come about?
I had practiced by myself, and then I had a law partner for about 10 years. And then I was recruited. Well, one day I came in, I see Atlanta Bar Association Minority Directory, all African Americans and females. So I called Reese Smith up. I don't know if you remember Reese. He may be a little bit before your time.
Yeah.
He was on the Atlanta Bar Foundation board. I said, Reese, what do I look like? A potted plant? and we chatted a little bit. So about a month after that, he called me up and he says, you need to put your money where your mouth is. So I've signed you up for a couple of bar committees dealing with minorities and so on and so forth. Alice Bonner was one of the chairs. And on that committee was Linda Klein. Linda eventually became the bar president and then became ABA president. So I met Linda, and Linda came, and we became friends. And she said, "Why don't you come have lunch?" So she's at Gambrell and Stokes. David Gambrell, Senator David Gambrell,
Sure,
who succeeded Russell, and before Sam Nunn was appointed by Carter, and that's the Gambrell. And Irving Stokes. Irving Stokes was Gambrell and Stokes. He was a Court of Appeals judge. So both Mr. Gambrell, Judge Stokes, Linda, all of them have been bar presidents. So they said, well, you want to come practice law with us? I said, well, I'm a mom and pa lawyer. I don't know anything about what y'all do. He says, well, we need a Mikey every now and then. Somebody who can just sort of, eat what we put in front of you. I said, yeah, all right, that sounds fun. And he said, my goal is to become a judge. And they said, well, we support all of our partners. It's good to have people in the judiciary of alumni. So I became a partner at Gambrell and Stokes for about 3 years and decided that I want to take a shot. All my partners were totally supportive, and it wasn't for them, I would never had the opportunity to run. Because, as a partner at a law firm, you have obligations. And they basically says, we're going to give you a sabbatical, relieve you from that obligation, and you can go take on a campaign, which my wife ran.
Right.
And to this day, she reminds me how much I owe her.
As she should.
And that I have to listen to her, which I do. Well, most of the time. Yep. And embarked on a run for state court in DeKalb County.
And you've been on the bench now 25 years?
This is my 25th year here.
And I think I read that you have not had any opposition in your time. Is that correct?
Well, we had opposition the first time.
The first time, right. After you got on the bench, though.
There was 5 of us that ran. And I was in the runoff with African-American female lawyer Mary Lee Davis. And we got in the runoff, and I beat her by a whopping 430 votes and got on the bench. But I've not had opposition since. I'm in my 7th term.
Which is a real testament to your reputation, Judge Wong, because that's, as you know, there are people out there who love running in contested races, and they just put their name out there. And it says a lot that nobody's been foolish enough to throw their name in against you. Well, I've got to ask you. So you've been presiding over 25 years. I can't imagine the number of civil jury trials you presided over. I mean, all different areas. Of course, I do a lot of medical malpractice, other catastrophic cases. But the question I got from my colleagues to pass on to you was the view from the bench, but not the typical one. Not the, lawyers need to show up prepared and be civil and respectful. I mean, those things that we all know. We learned that in law school. I'm more interested in your experiences with some of the crazy things you've seen, some of the things you've seen that the changes you've seen in jury trials. So I'll start off with the crazy. What are some of the more bizarre things you've seen in presiding over civil jury trials?
I think I can't remember anything really just totally off the wall, but the general thing that strikes me as being amazing about jury trials is that how many times that lawyers come in, and I'm talking about not only from the plaintiff's perspective, but also from the defense perspective, that have such a myopic view of the world.
What do you mean?
Well, you know, when you go on trial, the old adage is good cases don't go to trial,
Mm-hmm.
right? It's the bad cases or the cases that you cannot reach a compromise on. You're so far apart. So everybody has got a little impediment in their case.
Mm-hmm.
And it always amazes me to see how many lawyers don't recognize what hurts them in their case.
Mm-hmm.
It's a sort of a blinder, and they refuse to acknowledge that there is a speck of dirt in their case.
Mm-hmm.
And just march down the trail. You know, if it's a damage issue, they've tried liability. If it's a liability issue, they try damages. And at the end of the day, even when they lose, they look at you and go, how can I have lost? That's the most amazing thing to me. It's just like refuse to recognize that you don't have the perfect case.
There's almost a psychological component to it, because it's almost as if you speak of the thing you're afraid of, most afraid of, you breathe life into it, and it's the monster under your bed. You know, the thing you're afraid of, you don't even acknowledge yourself, or you talk yourself out of it.
Oh, totally. And or the flip side of that is that if I don't talk about it, it won't happen.
Right. We'll just pretend it's not, that the defense has overlooked
Yes.
the biggest weakness in the case. I have heard a story involving you, Judge Wong, of how you run your courtroom when the occasional witness will show up who is less than respectful of the court and less than appropriate for the setting. And I heard a story where you presided, where a defense expert, a medical doctor, if we can get the story straight, was testifying. There was an objection. The objection was sustained, and the doctor continues testifying and says, "Well, as I was saying before, the judge interrupted me," and then continued to testify. And I heard that you had a reaction to that comment from the doctor. Do you remember the case?
I don't remember specifically the case. I sort of remember the occasion. You know, nowadays I'm a little more mellow.
Well, the story, since you don't have the vivid memory of it, maybe this will refresh your recollection, as we say. It was a medical malpractice case, and this expert had testified at his deposition that when asked what caused the death of this patient, his response was, "Well, God only knows," is what he said. But then he shows up in trial, and apparently he had developed a new theory of causation, which he offered. He was being cross-examined about it. This was a trocar case that went into the patient and didn't deploy properly and caused some internal damage. And he shows up in court, and objection sustained. And then he commented about how you had interrupted him. And the way I heard the story was that you politely excused the jury, and then you had a discussion with this witness about what it means to be respectful to the court and what's appropriate and what's not. And it made an impression. I'll just put it that way.
Well, I'm surprised that I would even have a discussion, and two, that I would do it outside of the presence of the jury.
Well, that may be a euphemism, but
yeah, I probably just ripped him a new one.
I think that's what I heard too, a little less delicately. Well, tell us what you've seen with juries. I mean, you have the advantage, and I guess some judges might say a disadvantage, that you have to be more passive and observant and not as participatory obviously you would be as a trial attorney presenting the case. You also have the benefit of seeing the things that's actually going on in the courtroom, the gestalt they talk about, the feeling of what's happening. Talk to us about some of the observations you've made about how juries decide these, very contentious, sometimes contentious cases.
I think the common theme that I have over the years noticed is that juries are very smart.
Yeah.
They're very smart people. And this goes across the makeup of the jury. Whether it's more this, more that, more male, more female, more conservative, and so on and so forth. Despite the different makeup of juries, the common theme to me has always been that very smart. You don't have to do a whole lot. In fact, I think if I have one piece of advice for folks coming in to try cases, is that because juries are so smart, you should leave a little bit to their imagination.
Mm-hmm.
You don't have to lay it all out there.
Give us an example, if you can.
Well, I mean, if somebody's driving 100 miles an hour and there's this huge wreck, or if a doctor just left a surgical instrument in the body, okay, you show enough to know that at the end of the day, that piece of equipment could not have been there, but for, all right, the car would not end up like an accordion, but for. You put up enough evidence and you let a little bit of the imagination of the jury do the work for you. Yeah. One of the worst thing I say happens in trial is this term, "Oh, I just want to make sure, Judge."
Mm-hmm.
You don't have to. It's done, If you have to say, "I need to make sure," that means that you plowed this ground already. And if you have a smart jury and you have a good case, leave it. Then they will do the work for you. I promise you.
Well, of course, in Georgia, we have unanimous juries, as you know, our listeners may not. And it's not always easy to get 12 people to agree to many things in this world we live in now. Have you seen divisions, I'll say just politically or across the left-right spectrum? Have you seen the divisions that we obviously know about through the news appear in court and manifest in jury trials?
No, actually, I have not. Because folks don't talk about what their politics are in jury selection.
And why is that? I'm curious your view on that.
I don't know. I think we are very careful, or at least judges are very careful in controlling the setting such that those kind of questions don't get asked. I'll give you a great example one day. I have a panel juror sitting there, and this woman was sitting at the end of she was on the panel. She was dressed, you thought she came from the 1960 Hay-Ashbury day. Okay? The hair, the dreads, a Caucasian woman, flower child.
Yeah.
Immediately you're thinking, the VW bug bus, the flower child, smoking marijuana, and so on and so forth, right? She perfectly looked the part. She had a book in her hand. It was a book by Bill O'Reilly. Okay, so what do you think of that? Is she reading to see what the other side is saying? Is she a believer? Mm-hmm. What is her politics? What is her personal view? So you see something like that, and then I think lawyers would try to be very careful and not stepping on any toes.
Mm-hmm.
And so those questions don't really get fully explored. I mean, in tort cases, those kind of questions get explored. And the only thing that you really care about is a juror's view of damages.
Mm-hmm.
Would they award money of a significant amount if they find significant injury? That's the only concern, regardless of politics. Well, I would suggest to you there are folks on both sides that would say yes to that question.
Mm-hmm.
So I don't know that politics, it's all that significant.
Mm-hmm.
I think personal experiences are very significant. I had a mother that had that happen. I had a brother that had that happen. I have a dear friend that had happened. I care for somebody that had that happen.
Mm-hmm.
Those sort of touches to personal feelings would influence verdicts rather than, I think, politics. You know, let them be in your shoes. It's never really an issue or a problem unless you've been in their shoes.
Mm-hmm.
So I just find that really pretty amazing. And then I think lawyers, we all practice law different, all have different style, have different ways of doing things. In jury selection would probe those kind of questions or issues. The bottom line is, if you find for me, are you going to be able to award significant damages?
Mm-hmm.
And if your answer is yes, or if I'm comfortable that you are a yes, I really don't care what your politics is.
Well, and you make a point that really connects with my view too, is that folks come in with all kinds of politics and personal experiences, but there's a commonality in tort cases. I mean, nobody is immune from being a victim of medical malpractice. We're all going to be in the healthcare industry or the healthcare system at some point, some more than others, and everybody is vulnerable to some extent, or vulnerable when they drive their cars. Somebody could run a red light, get hit by a drunk driver. So it seems that politics, at least my experience has been that they're secondary issues, and it's more about, like you talk about, the common experiences that people can relate to. They see themselves, in this situation or this story being relevant to them. We hear a lot of pushback on, they're trying to, violate the golden rule. But whether anything is said or not, just being human beings, we tend to imagine ourselves in the story. Is the doctor being treated fairly? Is the hospital being treated fairly? Whatever the setup is. So that's interesting. I think it's very insightful, Judge Wong. I agree with your perspective on that wholeheartedly. Can you tell us what the biggest mistakes that you see trial lawyers make beyond the not being prepared? You've touched on it a little bit, maybe over trying the case and not leaving enough to the imagination. You've got a lot of experience watching a lot of different styles of trial lawyers. What, in your view, what are the things that lawyers routinely do that are seem just misguided, that just don't land?
There's different grades of trial lawyers.
Mm-hmm.
From the very young, inexperienced, to the very seasoned, very experienced.
Mm-hmm.
And even in that level of, or what I call different grades, there are some that just have it innately better, got the speaking skill and so on and so forth. So I wouldn't call any of those performance issues or what I call forensic issues to be impediments, to be problems. I think this is the story I like to tell. My point is, in the Japanese world of manufacturing, there's a system called Kaizen, which means how do we make or how do we produce a product? So the way in the manufacturing world they would do is they would figure out how many parts, what parts to make a widget. Lawyers would have the widget and not know what the parts are. Okay? They look at the widget, they don't look at the parts. So what does that mean? It's really late and really a problem when you sit down to do jury charges and you figure out you got an element you haven't proved.
Mm-hmm.
Well, you need evidence to shore up what the law says you got a problem with. So, the joke is, how do you know a lawyer's on trial? Well, he's in the library working on charges.
Now it's in front of your computer, but
now it's in front of your computer. In those days, in the library, he's trying to put charges together. That's the last thing you do.
right.
I would suggest, well, for somebody like you or folks like you who do one particular kind of case, you sort of have that down pretty much. You know what the latest issue are, what and what you have to prove and what the new law is. So it's not really anything that you have to worry too much about.
Mm-hmm.
But I think for most lawyers trying cases is know what the law is first. Start with knowing what the elements of the case is going to be. Then put your evidence together. Don't put your case together and say, oh, I'm lacking this at the end because I hadn't looked at the law.
That is the wise words, Joshua, because you're exactly right. It's the backwards way to do it. I had a judge or a senior attorney tell me years and years and years ago that the starting point for any new case are the jury charges, and you should read the jury charges when the case comes in, particularly if it's an area you haven't dealt with a lot, maybe products liability or medical malpractice, whatever it is, and start with the law and then work your way forward. Don't go the other direction.
Yes. I was a baby lawyer. I was trying a case out in Cobb County, got a directed verdict against me on the corporate entity, which is the only party that had any money. Learned that lesson quickly.
Oh yeah. I tried a trucking case years ago, and it was a wrongful death case in federal court. And my co-counsel and I were debating whether we wanted to put in the death certificate into the case. And for whatever reason, we decided not to. There was something else on there we didn't particularly want in the case. And we get up the end of the evidence, and the defense says, well, you haven't proven the person died. And the tractor trailer had run over this poor lady in her car, and no question they killed her. But I had cross-examined the driver, and the question that saved us is I said, well, you don't deny that this impact is what caused her death, do you? And he said, no, I don't deny that, and just kind of said it offhand. And the defense was licking their chops, hoping they got us out on directed verdict because we hadn't proven the death in a wrongful death case. I mean, those kind of things drive you crazy. But
those are the kind of things that you live and learn.
Oh yeah, there's no substitute for experience.
Yeah, sometimes you get bailed out, sometimes you don't.
I try cases with one of my dear friends, Laura Shamp, who I know you know, and she's been in your courtroom before, and just an excellent trial lawyer, and just a lot of fun to try a case with, and highly capable, very talented woman, lawyer here in town, and she has a checklist, and she calls it her directed verdict checklist, and she has all the elements out. She has a grid, and she keeps track and makes sure that the witness testifies to the points we need testimony on, so nothing gets overlooked. It's that's one good reason it's important to have a solid co-counsel with you, because you just can't do everything. Now, there's some other things I want to ask you too. I'm shifting away from the actual trials a little bit, and I'm going to talk about ask you about one of the issues that just drives me and my colleagues crazy, which is recalcitrant defense counsel not producing discovery, not answering discovery responses, playing games in depositions, not answering questions, kabuki theater with the witness. You ask a good question, but it's a topic they don't want, so they object to the form. They'll interrupt it and signal the witness. And of course, not everybody does this, but there are some who do, and you know who you are if you're listening. And so the complaint is we'll go to judges and say, well, here they're not answering interrogatories, they're obstructing depositions, they're not giving us, most importantly, they're not giving us the documents we're entitled to. And then not you, but some judges just act like it's horrible to have to deal with a discovery dispute.
Oh, it is. I'm including me in that.
Okay, I'll include you in there. And then they get mad at everybody for having a discovery dispute. And then if they ultimately agree that, yeah, you were entitled to these documents, the judge doesn't give you attorney's fees for all the time it's taken. And it just becomes like a 3, 4, 5 month delay to get what you're entitled to out of the box. So I guess my question to you is, how do you handle discovery disputes, and what recommendations, if any, would you give to attorneys, hitting that wall of obstruction?
I think the best thing a lawyer can do, and this goes to, it's true on both sides. There's difficulty in obtaining information from the defense and likewise from the plaintiff. I've seen this plays out on both sides of the aisle. So my comment is not targeting towards the defense or the plaintiff, but just difficulty in discovery, which is probably where you guys spend 90% of your time on cases.
That's probably true.
Okay. So a couple of observations. One, if that were the case, let's keep discovery simple. Figure out what you need and only go get what you need. Because I will promise you, of those boxes that you brought into the courthouse for trial, 99% of them, the lid won't even be open. Okay?
But you know how it is, though. You have to go through all those boxes to find the 10 documents that matter.
Well, sometimes.
Yeah. So,
and I'm glad I don't have to do that, but you guys do. And I know this happens a lot. So the way I deal with it is, I think the first thing a lawyer can help themselves in doing is the 6.4. All right. I mean, properly utilize the 6.4 requirements. And I don't mean just sending emails or leaving messages. I mean, insisting on a conference and a call with opposing counsel.
Well, Judge Wong, let me expand on that a little bit for our listeners who don't know what we're talking about. But in Georgia, there's what they call the 6.4 rule, which basically means you have to conference or consult with the other attorney about the dispute before filing a motion to compel. And the idea is to get people talking to each other and working to resolve things in good faith before filling up your docket with motions to compel.
Correct.
Yeah. And
so the pre-filing of the motion to compel motions, the precursory of doing all that is an earnest effort in outlining or narrowing what the dispute is. I think if you go to any judge and said they won't produce, I've sent them 65 interrogatories, they hadn't answered 50 of them. Or I sent them a request to produce for all of these things and they produced none. And here's the list of all the documents and all the questions that you have to look at, Judge. well, you're not going to get a very receptive answer.
Mm-hmm.
But if you came and said, of those 50 questions and 64 interrogatories, of significance to the plaintiffs are 3 things, Judge.
Mm-hmm.
And this is what we would like the court to focus on and get the defense or the other side to explain why they haven't been produced and why we could not get them.
Mm-hmm.
So narrow the dispute for the court. I will promise you, if you did that, the judge is going to be very appreciative of your effort.
Mm-hmm.
I like to resolve these things with a telephone.
Mm-hmm.
In the old days, I just pick up the phone and call the lawyers. Now I can send a Zoom call.
Mm-hmm.
Okay, let's get on Zoom. Let's talk about it. What's the problem? And I think most of the time we've come to resolution, or at least a mechanism for resolving the dispute.
Yeah.
Conversation. Now that presupposes your judge is inclined to do that.
Mm-hmm.
I'm very inclined to do that because I don't have to read a bunch of papers. My clerk doesn't have to read a bunch of papers.
Right.
I cut to the chase. I can cut to the chase. All right. And then the next 2 that I like is that lawyers have my cell phone number.
Mm-hmm.
In discovery and depositions, I invite everybody to call me. Call my chambers. Call my cell. If I'm on the bench, send me a text. I will get off the bench and call you right back.
Wow, that's generous. I'm not sure I've got your cell number. I need to follow up with you on that. But that's very generous. A lot, of course, a lot of judges, don't have that accessibility. I mean, some do. I mean, I can think of 2 or 3 offhand who have a similar approach. Let's talk it through before we elevate this to a bunch of docket work and motions practice.
So narrow the scope of the dispute, talk, meet with opposing counsel, with the judge. I'm accessible that way and by phone call. Or, worst come to worst, I set the deposition in the courthouse. So I'm right down the hall. Okay? You guys want to bring video to tape it? Great. I got a conference room. Tell me when. I'll schedule it for you. I'm going to be here. Or if I'm not here, my secretary would know how to reach me.
Your former colleague on the bench, Judge Lopez, who's in private practice now, invited me and defense counsel to take depositions in his chambers. And it was an invitation with the expectation you're going to follow it or else.
Right. I mean, when that happens, there's just no dispute in the deposition.
That's right. That's right. People tend to get along better.
Yeah.
What do you do in the situations where a lawyer is just flat out misleading you, citing a case and saying it says one thing, it says the other, claiming they've got a conflict. You make a phone call, you realize that they don't have a conflict, trial conflict, for example. They just say things to you that aren't true. First of all, has that ever happened to you?
Oh, I'm sure it happens on a regular basis.
Yeah.
I don't mean to impugn lawyers in this way. Especially nowadays, we're all asked to do more than what we got. Do more with less.
Mm-hmm.
Everybody's busy. Everybody's got to be. And I don't see so much in specially set big tort cases. Everybody's going to be ready. Everybody, I get a bunch of misdemeanor cases and trials, high volume kind of work that say I got to be here. I got to be there. I'm totally don't have a problem with you got to be somewhere. Okay. From my perspective, if I don't get you, I got another one behind you. or in front of you. So my day is filled with you or with somebody else. But what that does do when you get caught in untruths is that you're never going to get a discretionary ruling.
Mm.
You may never know it, but you are not going, when there is a way for a judge to resolve a matter in your favor and you're on the bad side, you're not going to get that call. That's it. It's very simple.
Yeah.
And you know, and I tell everybody, we have a state court, we have a conference twice a year. All the judges get together, right? Lawyers talk about judges. I will promise you, judges talk about lawyers.
It's probably not always favorable.
That way, you know, the good ones get accolades quickly. The bad ones get talked about incessantly.
Let's make the best stories, probably.
Yeah.
You're not going to believe this.
Yeah. And you know who the bad actors are. It's amazing. Yeah. It's always the same crop. You know? Those are the people that don't ever get any discretionary calls, ever. Yeah.
Well, Judge, a couple more questions and we'll wrap up. But this has really been interesting. But I feel like I want to, if you can stick around for a few more minutes.
Sure.
Give us an idea. What is the perfect day on the bench for you, or being a judge? I mean, do you get excited about the lawyer activities, the GTLA events or the DRI events? Do you get excited about a new trial? Criminal matters excite you? What's the best day for you on the bench in terms of just your personal preferences? Understanding that you like everything about the job.
Come in here at 11, leave about 3 with a nice long lunch.
Yeah. We got that on the record now.
No problem. I don't have a problem with that. Well, listen, for what I do, the best is when there are resolutions. Okay? Be it a criminal case, be it a civil case, that the litigants have ended their disputes. And that I, as the neutral, facilitated that. That's the best day.
Mm-hmm.
You know? So on criminal days, if I pled out a bunch of cases, in civil case, I've done a bunch of settlement, because you also know that I call it mediating or settling, conduct a lot of settlement conferences in civil cases.
Judicially hosted settlement conferences.
Yeah, whatever. the browbeating stuff.
Yeah, exactly.
To me, the best days are days that I can resolve matters for people. Yeah. Okay, and I enjoy going to the events. I enjoy seeing everybody. We're all social animals, and all of that. And I like to come to work. In my younger days, when I was a younger judge, I try a lot of cases. My first month on the job, I tried 13 criminal cases.
It's a busy month.
And so now I don't try many cases. 3 or 4 big cases a year, maybe a handful of, 2 or 3 days, a handful of criminal misdemeanor cases. I just don't try that many cases. But because I've learned in pretrial settings, you can find resolution or suggest resolution. So the best day for me would be days that I've helped resolve disputes.
Well, I know you're busy and you've got a lot going on, and it's incredibly generous of you to find time to talk with me. I wasn't sure if you'd have time when I raised the possibility of you being a guest on the podcast, but this has been really enjoyable for me personally. I enjoy, obviously, we see each other in and out of the courtroom, and you are well liked, well regarded as a real lawyer's judge, which is the highest compliment lawyers can pay a judge, frankly. And I appreciate you and appreciate you finding the time for us today. This has been fun.
Well, thank you, Lloyd. I enjoyed it very much. I'm glad you're doing this because this also takes time for you to be away from your practice, but you seem to manage that quite well and got a great team and put podcasts like this, talk about different things, different topics. I think that's folks like that, and I hope you have a big lay audience out there that finds this interesting for them. And thank you for inviting me. I thoroughly enjoyed participating with you.
Well, thank you very much, Judge, and I will look forward to seeing you soon, either inside the courtroom or outside. So
Very good.
you have a good rest of your day.
Thank you very much.